Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Hi there, and welcome again to Ask a Lawyer here on CP24, where we shadow the myths, misconceptions, falsehoods about employment law and your employment law rights. John Scholes here, your host, and joining me very shortly, my good pal and employment lawyer, Lior Samfiru from EmploymentLawyer.ca. Reach out anytime. First, the phone call, right? 1-888-861-4555 and ask at EmploymentLawyer.ca. Anytime you'd like, confidentially, you can reach Lior and his team. There's also a website which will come up several times during the show. I can almost guarantee it, PocketEmploymentLawyer.ca. That'll tell you about 95% of what you need to know about your employment rights. And rolled into that, baked into that website is something we call the severance pay calculator. That has been used by over 2 million Canadians, and it will tell you exactly what that severance number should be anonymously. It takes about 30 seconds to go through it, so at your leisure, you can use that anytime as well. On the show today, probationary periods and termination rights. That's here in just a bit. And we'll get to that, some live phone calls, or at least phone calls from our live radio show, which you can catch, by the way, Sundays, 1 p.m. on News Talk 1010. But Lior, we always start things off. We get warmed up, as you like to say, with the week that was, something that came across your desk recently. Pal, what do you got?
Hey, John, it's great to be back here. And over the week, I've gotten so many questions, emails, phone calls from people that watched the show, seen me on here before, and wanted to understand how what they've learned on the show impacts them or had questions about their situation. That's great. That's why I'm on here, to tell you about employment law, to tell you about workplace rights, and to help you understand more about your situation. Maybe you're facing a difficult situation. Maybe your boss has done something, created a bad work environment. Maybe you're mistreated, bullied, harassed. Maybe you're facing a policy and you want to know how to respond to it. Or maybe the dreaded loss of a job, where you've lost your job. What does the law say about that? What are you owed? Can that even happen? Well, we talk about this on this show, but you can also reach out to me, of course, off air if you want to have that private chat. Remember, there are answers, there are solutions, there are good laws in this province. So if you want to know what the law is, a good place to start, a great place to start is right here on this show. To give you an example, John, let me tell you about a situation that came across my desk over the past week. I spoke with a gentleman that had been off work for over a year because of a medical condition. No issue there in the sense that his employer wasn't giving him a hard time. He got his doctor's note. He was getting better over time. And after a year or so, he was cleared to go back to work. He contacted his employer and said, I'm ready to come back. His employer said, great, good news. Give us a couple of days and we'll get back to you. After a few days, the company responds back and says, listen, your job, your old job is no longer available. We looked long and hard, and the only other job that's available for you is this other job. This is a lower paying job, pays you about 25% less, but we think you do a great job there, and if something else opens up down the road, we'll put you back into that role. So he was obviously confused and a bit upset. He doesn't want to take a 25% pay cut. So he called me and he wanted to understand what his rights were. So here's how this works. His employer has to make all efforts to bring him back to his old job after his medical leave. Now, in this situation, it does appear that the company has made those efforts. They've tried, they've looked, and the only thing that was now available is this lower paying job. So what does that mean? Well, despite the fact that the company is not trying to hurt this person, they're not being a bad employer, this 25% pay cut is still a significant change to the terms of his employment. Therefore, it's a constructive dismissal. So even though the company doesn't have another job, if their only option is to reduce his pay, he can consider that. He can treat that as a termination of his employment, constructive dismissal, and get his full severance. This is a long service employee. He's going to be owed 24 months of severance. So I wanted to remind everyone there that coming back from a medical leave, coming back from a disability leave, if your job changes in a significant way, it can easily be a constructive dismissal, even if the company is acting in good faith. And of course, beyond that, in any situation, if you're facing a demotion, a pay cut, a relocation, any significant change to the term of employment, that concept of constructive dismissal should come to mind. And if you're not sure how it works or what to do with it, just give me a call.
And you can do that. Reach out to Lior anytime, as we mentioned off the top. 1-888-861-4555 is how you do that. Ask at EmploymentLawyer.ca through email. We did mention as well, Lior, that you and I have been doing radio shows across this country pretty much for a decade. EmploymentLawyer.ca. Find a station near you, including Sundays, 1 p.m. on News Talk 1010. We get a lot of calls coming in. People want to know stuff. We play them back here a couple times during this show, and we talk about them. First call for today is coming up right now.
3 weeks ago, my boss came to me and said, doesn't want me any part of the department anymore. Today actually came to me with one viable option within the company, and it's nothing anywhere close to what I'm doing now. How long do I have to act on this before I can no longer take that route?
How long have you worked there for?
Over 15 years.
What kind of a job?
Accounting. I just turned 40 in October.
So, John, here's how this works, and this ties in nicely to what I was talking before about constructive dismissal. So his employer doesn't have the ability to just demote him, giving him a lower level job. So here's what he can do in this situation. Number one is he can tell his employer, no, I'm not interested in this. Thank you very much. I just want to continue in my current job. So his employer can do one of a few things here in response to that. Either they back off and they leave him be in his position, that's great. Or they may decide to let him go, in which case severance has to be paid. Or they may decide to make that change anyway, which would be a constructive dismissal because they don't have a right to do that. So in that situation where the company changes his job, as I said, that's a termination. Can't be treated by him as a termination of employment, and now severance has to be paid. The question now becomes, how much severance? Mm-hmm. So, of course, to do that, we're going to go and use our handy-dandy severance pay calculator. You can find that, of course, at PocketEmploymentLawyer.ca. Again, it's PocketEmploymentLawyer.ca. And let's see how much severance this guy would get because of his constructive dismissal situation. So this guy is a 40-year-old gentleman in an accounting role, been there for 15 years. In a constructive dismissal situation, you see he's owed right around 15 months of severance. He's kind of a classic month per year person. So that's a significant amount of severance that he's going to be owed, even though he's not let go, even though the company, all it's doing is changing his job. So if you're in a constructive dismissal situation, you can do the same. Go to PocketEmploymentLawyer.ca, use the severance calculator, and find out how much you're owed.
All right, good stuff. Let's take a short break, Lior, on the upon a return, probationary periods and termination rights. That is on the way. In the meantime, reach out to Lior anytime you would like. 1-888-861-4555. We'll continue with more Ask a Lawyer. Stay with us.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer here on CP24. Thank you so much for sticking with us. Want to get into our topic for today, but before I do that, I'll give you some contact information for Lior and his team. Reach out anytime you would like. 1-888-861-4555 on the phone, and email ask@employmentlawyer.ca. Probationary periods and termination rights. Let's get into this straight away, Lior. Question number one. A lot of people think they know, but what does it mean to be on probation?
So a probationary period, or probation, is the idea that an employer and employees have a right to take some time to figure out if this is going to work. So for the employer to determine if the employee is a good fit and whether they want to keep him long term, and for, of course, for the employee to decide if that employer is the one that they want to work for. The idea being that if the employee wants to leave, they can do so with little or no notice. And if the employer wants to have the employee to let them go, they can do that with very limited severance obligations. So it's a period of time to try things out.
So if I put my employer hat on now and I decide to hire a new employee, are they automatically on probation from day one?
So that's the key here to understand is probation is not automatic. Probation is not created automatically by law. It has to be created in an employment agreement. Therefore, an employee is only on probation if they sign an employment agreement specifically putting them on probation. If you didn't sign an employment agreement that puts you on probation, guess what? You're not on probation, even if you just started a new job.
That probationary period, though, how long can it be, and can it be extended legally?
So if the goal of a probationary period is to allow the company to let you go without severance, that length of time can only be 3 months, 90 days. It can't be longer, because after 90 days, regardless of what the company wants or what you've signed, if you're let go, you're going to be owed severance. So as a practical matter, no, probation cannot be longer than 3 months, and an employer can't really extend it. If they could try, but it's meaningless, because you can't be on probation. You can't be let go without severance for a longer period than 3 months.
Next question is this, Lior. If we go back to the aforementioned employee that I just hired, I'm not happy with him during the probationary period. What can I do?
So certainly an employer is expected to give feedback to an employee, to give him an opportunity to improve, to understand what's expected of them. So in other words, an employer does have to act in good faith in assessing the employee. They can't just make it arbitrary. So if in fact during that period the employee is determined not to be a good fit and the employer has acted in good faith, then that person can be let go without severance. Now, of course, only though, John, only if they sign an employment agreement that specifically gave the company the power to do so. Because if they didn't sign an employment agreement like that and they're let go in the first 3 months, yes, even in the first 3 months, you could be owed a substantial amount of severance. I've represented many people that were owed months of severance, months, even though they worked there for 3 months or less.
We're talking about probationary periods and termination rights. I'll ask you one more question, Lior. Are there times when an employee should kind of refuse a probationary period?
So if you're coming there because you were recruited away, or you're leaving a secure job to come to the company, don't agree to be on probation. Don't, okay? Don't leave a secure job just to be on probation. And if, in fact, they want to put you on probation, don't ever give up rights by doing so. And if you're already working for a company and they want to put you on probation, it's meaningless. It's not something that you should accept. So keep that in mind. Sometimes probation is not a good thing to do, and if your employer puts you on probation or threatens, you may want to give me a call.
A reminder once again, guys, EmploymentLawyer.ca is the place to go to find a radio station pretty much across Canada where Lior and I will do an hour-long show, including the big one here, News Talk 1010, Sundays at 1 p.m. We're going to get to call number 2, Lior, from our radio show right now.
I have been off work now for 3 years, and I've got long-term disability for 2 of them. I'm actually fighting it now to get my benefits reinstated. Now, if at some point I get better, does the company have to take me back on my job?
So great and a common question. So the way it works is once he's able to go back to work, once he's cleared to go back, his employer has to make all efforts to bring him back. They have to either try to bring him back to his old job, and if that doesn't exist anymore, if it's not available, they have to look elsewhere and see where he would be a good fit. They can't ignore him. They can't avoid bringing him back. They can't do anything to him other than try to bring him back. Now, if there isn't a job, they've tried, they've looked, and there's no job, then and only then, okay, can the company consider letting the person go with severance, okay, with severance. But beyond that, an employee should always be taken back to work. And if you're not being brought back to work, if your employer won't cooperate with bringing you back, that could be a human rights violation. You have to give me a call right away.
All right, we'll take another short break, Lior, and when we come back from the break, the validity of annual contract renewals and getting work below your pay grade. We'll tackle that on Ask a Lawyer. Stick around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
right, welcome back to Ask a Lawyer. John Scholes here alongside employment lawyer Lior Samfiru from EmploymentLawyer.ca. Do not hesitate to reach out to Lior and his team anytime. Phone calls 1-888-861-4555. Email is ask@employmentlawyer.ca. And as mentioned, we do a ton of radio shows across the country. You can catch us Sunday, 1 p.m. on News Talk 1010. Lior, let's get to the third phone call from our radio show now and talk about it.
I'm a sales rep for a company, almost 13 years, 58. And every year we have our end of the year meeting where we discuss what we're going to be doing in the future for as far as business, what our commission structure is going to be. Now, they call that our contract. And if we don't sign it, what they tell us is that by not signing it, you are in fact quitting. Now they're starting to put things in place which are actually going to hurt me. But I work for the company. I mean, it's not like I have my own company where I write things off. So I'm an employee, but they're calling this a contract. Can they do that?
So the real question here is, what are they doing that's different than what they've done before? Because remember the rule, your employer can't just change the terms of your employment. So he says the company is doing things that will hurt him. So what new terms are they putting in that he did not have before? Is it terms that change his compensation? Are there terms that allow the company to get rid of his commissions? Bottom line is this: if the company now wants him to agree to terms that he did not agree to before, that were not part of his employment before, he can say thanks but no thanks. And no, that's not quitting, because the way the law works is you're the only one that can decide if you quit. The company can't consider you to have quit. There's no such thing as deeming you or considering you to have quit. So if he loses his job, it's because they've terminated his employment, not because he quit. And that means that, of course, he's going to be owed severance, full severance. So let's go back to PocketEmploymentLawyer.ca. Let's use our severance calculator. And actually, let's see how much severance he's going to be owed in this situation. So we know that he's in a sales type of a situation. He's been there for 13 years. He's 58 years of age. If he is let go, he's owed right around 16 months of pay. 16 months, okay? That's how much severance he's owed. That's what he'd be looking at in that situation if they make him agree or try to make him agree to terms that he did not have before, John.
You know, in addition to radio shows, TV shows, practicing employment law, Lior also hosts a ton of very educational live streams on YouTube and Facebook. You want to join in anytime, go to stlawyers.ca. And a question that came up recently, Lior, from that live stream, we'll give it to you right now, says, lately my supervisor has been talking to me in a humiliating way, often in front of coworkers. He's also assigning me work well below my pay grade and outside my actual role. How should I respond?
Well, what he needs to do in this situation is tell someone, tell HR, tell the owner, tell whoever the right person is within the organization. Give them an opportunity to do something about it, to the fact that he's being mistreated, that his job is not properly done. So by telling them, the company has that legal obligation to deal with it. If they refuse, okay, that could be a constructive dismissal because they're making significant changes. But I only want to deal with that once he's given them the opportunity. If they don't do something, he calls me, and we can absolutely consider that to be a constructive dismissal. But let's start with talking with the company, John.
Quick question for you. You ever been late for work? How about that? Well, one company is going from a 3-strike rule to a 1. Is that even legal? We'll tackle that after a short break on Ask a Lawyer. Stay around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer here on CP24. Employment lawyer Lior Samfiru, always at your service at EmploymentLawyer.ca. Reaching out on the phone numbers 1-888-861-4555 and ask@EmploymentLawyer.ca. Lior, I have one more question for you. Came across your desk recently. It says the company's new policy is that if you're late for work just once, you can be fired for cause without severance, no matter what the reason is. Are you legally allowed 3 strikes?
So, John, this is a situation where the punishment must fit the crime. So no, you cannot, absolutely not be fired for cause for being late one time. No way, there's no world where that would be cause, because cause is reserved for the worst offenders. You can only be fired for cause if what you did is so bad, so outrageous, so over the top that you just can't be employed anymore. And being late one time is not going to do that. Now, in terms of 3 strikes, it does depend on the situation. The more minor the offense, the more opportunities you need to be given to improve. The more significant the offense, the less opportunities you need to be given. So bottom line is, 2 or 3 or even 4 is generally the rule. I like 3. So if someone does something wrong, the employer should give them a warning. If they do it again, they should be getting another warning. And finally, maybe a final warning, and then considered for termination for cause if they really, really don't get it. But no, you can't just be fired for cause because you did one thing wrong in most cases.
Is a one-strike rule, is that something that an employer can write into an employment contract from the outset, or no?
No, you can't get around the law in that sense. You absolutely can't. Now, they can say that if you commit a serious offense, like hitting someone, committing fraud, stealing, yeah, that's going to be cause. But beyond that, John, it's simply not going to be. The law is going to make that determination.
Yeah, you often referred to in the past as the capital punishment of the employment law relationship. So describe a little more what that means in our remaining minute here. How bad does it have to be?
So the offense that would allow the company to let you go for cause without severance has to be so bad that it's just not possible to continue employing you. Where that employment relationship can't be rehabilitated anymore. It's done. It's over. And that's a very, very high standard. The fact that you did something wrong does not mean you can be fired for cause. John, that would be a wrongful dismissal.
Always great information here, my friend. We're just about done for another show. You want to reach out to Lior anytime beyond this half hour. You can do so 1-888-861-4555. The email address we always go to is ask@EmploymentLawyer.ca, and just EmploymentLawyer.ca, the firm website. You will catch links to our radio show, that especially on News Talk 1010 Sundays at 1 p.m. Join us next week when we talk about times you cannot be let go from your job. We'll cover that off next week. And this show, of course, on CP24. You can catch that at CP24.com/ask a lawyer. Thank you so much for tuning in, and we'll catch you next week.